Yes! Hello, my beautiful friends. What an amazing day it is. Welcome back. I hope that your rest was absolutely outstanding. Your Tuesday has been amazing as well. We have a great live stream planned for us. Bunch of good updates today. Quick preview, then we'll come back and dive in. But big battle over evidence in the Comey case. And so we've got another parallel proceeding that's happening. Of course, the Comey case has been dismissed because Lindsay Halligan, they said, is disqualified. But now we've got this battle in this other case against Daniel Richmond. In this case, actually, Daniel Richmond is suing the United States to say, don't give us or don't give the prosecutors Richmond's emails. And remember, Daniel Richmond was this guy that James Comey was emailing to and allegedly leaking stuff out to the media. And so they used the search warrant evidence from Daniel Richmond to go after Comey. Once Comey's case got dismissed, then Richmond sued and said, they've got my evidence. Give me back my evidence, so that the DOJ has to dispossess themselves of it. And now the DOJ has responded. So we'll go through that. We'll see what their nice filing here looks like, fresh out of the oven today, out in the District of Columbia in Washington, D.C., the latest on the Comey case coming up. Then we'll turn our attention to Gavin Newsom. And shout out to our members only stream this morning for bringing this lawsuit to our attention. Pretty interesting one. And it's the DOJ is suing to stop in-state scholarships and tuitions and subsidized education for illegal aliens. And this lawsuit is now percolating over there in the Eastern District of California, United States of America versus Gavin Newsom. And so we'll go through this. We'll see what the latest is. This is coming out. Remember this name right here? Stanley Woodward, one of the attorneys who represented Walt Nauta on behalf of President Trump on the defense side before going back over to the DOJ right now. So we'll go through that. Got other reaction. We've got Mr. Guam Capsize, Hank Johnson, who is saying that America is basically the great Satan, which is interesting to hear from a sitting congressman. But we'll hear what he had to say. Some other clips from Gavin himself. And the president was out here talking about Somalia and immigration and illegal aliens. All coming up in the second segment. Then finally, we'll wrap it up with this order that dropped on the Ghislaine Maxwell case. And a lot of people, especially on the left, very excited about this. The Democrats on X this morning were posting, we got a signed order from the judge saying release the files. Well, we'll read through it. Apparently, there's not much in there. And we're probably going to have to set an over-under for the total page count on the grand jury proceedings, the transcript. Once that gets released, we'll see how long that is. We were contemplating setting the number of pages at about 50, maybe 55, might split people a little bit more. But we don't think there's much in there because it was led by Maureen Comey. And Maureen Comey was the daughter of James Comey, is the daughter of James Comey, and is not trustworthy in our opinion. So a great stream coming up. As you can see, 3 good segments. We had a great stream this morning. We talked about Senator Jasmine Crockett on our members only morning stream, which is a scary thought, but there's a little bit of interesting development there because if she runs, then they're saying that might pull support away from John Cornyn in the Republican primary, which might lead the way for Attorney General Ken Paxton, who would then obliterate Jasmine in the general election. So we might get Senator Ken Paxton as a result of that. Anyways, gamed all that out this morning on the members only stream. Shout out to our membos. Thank you for supporting our work here and becoming membos on YouTube or on Locals. We do member streams in the morning. We do Saturday shows. We'd love to have you. It's a great way to meet some other people and join us and support our work here. And we love you for doing that. So thank you. And now it's time to get into business on the day, presuming that our tubes are coming in loud and clear. Looks like they are. So let's do it, shall we? Here we go. The DOJ fights back against the James Comey prosecution dismissal that was coming down from federal judges. Now we see a parallel case is percolating out there, and the DOJ just submitted this motion to dissolve the temporary restraining order that was entered over the weekend after the Comey case got dismissed because the judge said that Lindsay Halligan is not validly appointed. Daniel Richmond, the law professor over from Columbia, who was sending emails back and forth with James Comey while he was a special government employee and while James Comey was the director of the FBI, that included classified information. He is now suing because, as we recall, much of the evidence that was being used against James Comey, because they were saying, well, he's a liar and he obstructed Congress, came from Daniel Richmond's emails. They executed a search warrant when the FBI was investigating themselves. They like to kind of smell each other and like, well, you smell good. You smell good. Is there any noxious odors around here? Not in the FBI. Everybody smells great over there. And they cannot find any problems. So we ultimately executed a search warrant. The FBI did. They went and they found Daniel Richmond. They got all his emails. And the FBI said, well, this seems pretty normal to us. Nothing wrong here. And they let him go. No consequences. They had 7 separate investigations that we know of, and they couldn't find anything. So then, as soon as the Comey case got dismissed, Richmond turned around and demanded his emails back. He said, those are really devastating for James Comey. Yeah, and I really would like to have those back. And so he sued, and a lower level judge granted it and said, the DOJ, give him back his evidence, okay? The actual damning evidence that would be used to incriminate Comey. He sued, and another judge said, give it back. So now the DOJ is saying, what the heck? And they submitted this. They say, all right, judge, you just issued an order saying we have to give criminal evidence back to somebody else who was in my opinion, co-conspirator. And now we're challenging this. Here's why. And we ask that you dissolve your TRO, which you just entered like 2 days ago. So they write to her. They say, all right, judge, look. The petitioner, Daniel Richmond, Comey's BFF, and whatever, he sent in a motion. He wants a return of property. He wants his emails back because those emails are devastating to James. It's actually a collateral motion to suppress, okay? It's not a motion for a return of property after the conclusion of a case. You get charged with a gun crime. They confiscate your gun. It turns out you're absolutely innocent. You get your property back. That's not what this is. This is Richmond trying to get the evidence that is damning for Comey back in possession and away from the DOJ. Instead, they say it's a collateral motion. It's kind of a sneak attack aimed at hindering the government from using that property as evidence in a separate criminal proceeding against Comey. And his request for preliminary relief, in effect, is a request that the government be stopped from an ongoing criminal investigation and a potential prosecution. And that's why the judge granted it. It's like, oh, crap. That evidence is terrible. Neither request is legally appropriate, says the DOJ. Now, Richmond's motion is not designed to secure the return of property that he needs or wants. It instead is a strategic tool, and a smart one too, to obstruct the investigation and the potential prosecution of James Comey. And granting it, Judge, but as you have, would have the effect of serving as a suppression ruling. Okay, we can't use this evidence because you ordered us to give it back to him. If Comey is indicted again, and that evidence, we went through it, all these emails back and forth between the two. Comey was using his fake email name, Reinhold Niebuhr, then was spelling names wrong so that it wouldn't be searchable. The guy is a scammer. If Comey's indicted again and the lower level judges are like, yeah, no, go get the evidence back. It'd be like, remember when Trump, when they were fake prosecuting him for false business records, it'd be like, well, if a judge just said, you can't use those records because they're Trump's. Trump said, you went in here and you got subpoenas for all my books, all my records. He got charged with spreadsheet crimes. Remember, one check, one cashing of the check, one entering in the ledger, crime, crime, crime. What if Trump just said, well, that's my property now, and I'd like to have that back. And the judge said, sure, sorry, Letitia, you can't have any of that because it's Trump's. That's exactly what's happening here, except they're framing it as a Rule 41G motion would be like a return of property after a case got dismissed in the gun example. Now, the judge are like, perfect. Here, all the evidence goes back, all of the damning materials. Similarly, the court's grant of Richmond's request for preliminary relief has stopped us. We've been asking, where is this investigation? Why are we not seeing an appeal? We want to see Lindsay Halligan, Alina Abba, and the others take their proper roles, their proper seats. And if their clock expires, where does that say that the federal government, the executive branch rather, is dispossessed of their appointment powers under the Constitution? Congress passed some legislation that said may appoint somebody, but not shall, and not that the DOJ is divested or the president is divested of any appointment powers. Absolutely unconstitutional. So here, potentially prosecuting Comey, it's all stopped now because they have no evidence. Another judge, Daniel, says, I want my property back. Judge says, here you go. But federal courts cannot enjoin federal criminal prosecutions. And a civil plaintiff cannot circumvent bedrock federal criminal procedure with a proceeding like this. So this court should dissolve this TRO and deny the motion. And if the judge doesn't do this, then a huge tranche of very damning evidence doesn't make its way out. Here's the background. Daniel Richmond, the guy we just saw in this photograph right here, Columbia law professor, he served as a special government employee at the FBI between June 2015 and June 2017. And there's going to be more on this because, here's footnote 1, the government has provided a concise factual summary herein out of an abundance of caution. Just so we all know, should the court have meant the TRO, the lower level judge, to permit the government to use materials that we got pursuant to search warrants, then we're prepared for a more detailed factual summary if necessary. So this judge is just limiting them. They don't even know the full extent of the order. They're saying, here's our first shot at this, but if you want more, we're happy to give you more. Saying here, now, shortly after his departure from the FBI, he leaves, the government began, and by the way, when he leaves, then they say he's Comey's lawyer. Okay, so first he's an employee, and we don't know whether he was entitled to classified materials at that time, whether he had permission to have these materials, or whether he had permission to share the classified materials with the media, which I'm doubting that he had at all. So even if you're an employee, yes, him and Comey can be transacting in classified docs. That's fine. He's an employee. But after that, or beyond that, outside of the scope of that relationship, he shouldn't be sharing that at all. And arguably he was. So shortly after he left, then he became Comey's lawyer. Now there's attorney-client privilege. And now you can't use that material against Comey because he was just talking to his lawyer, which is very convenient to be able to insulate yourself against criminal charges and basically exculpate your co-conspirators by just labeling them your attorney and then getting away with it for years. While simultaneously, they shattered Trump's attorney-client privilege when his attorneys were put under the gun by Judge Beryl Howell in Washington, D.C., where she said, oh, the crime-fraud exception allows us to breach attorney-client privilege. They're not doing that here, though, are they? No, this judge is saying all that evidence can go back to him. So we began investigating Richmond, says the government. And the question, of course, is whether this law professor had disclosed classified information to the New York Times, which we think there's plenty of evidence that he did, about Comey's decision-making process when it came to Hillary. Comey was devastated about Hillary, and he was getting ripped apart in the media. Remember, they were so mad at him. He thought that he was covering this up for Hillary. He's like, man, we got Anthony Weiner's laptop that's got tons of wieners on there or something. Not good. And deleted emails and all of the materials that Comey's like, I don't know what happened to those. Well, they got their hands on them in Anthony Weiner's email. And then he said, all right, we got to update Congress on this. He came out, made his announcement. They blamed him for losing the election. And he needed somebody in the media to push back. So he was sending stuff over to Richmond. Now, the investigation demonstrated that Comey did use Richmond to provide information to the media concerning his, that is, Comey's decision-making process about the Hillary Clinton email scandal. And Richmond was the anonymous source in doing so, okay? Co-conspirator. And the judge just said, well, all the evidence that might implicate him, you can't use it. You have to give it back to him because he wants his property back. Now, during the course of the it's amazing, like drug dealers, like, can I have my paraphernalia back, please? Yeah, all of it. Yeah, all of it. No, I'll bring the bus. During the course of the investigation, the government sought and obtained 4 search warrants in this district in D.C., authorizing the government to search Daniel Richmond's hard drive and his email accounts and forensically image his personal computer and his iCloud account. And they did all this and like, oh, he's one of Comey's. So not crimes. Comey provided relevant testimony to the Senate Judiciary Committee shortly before he was fired. And again, back in September 2020. In May 2017, he testified after Senator Grassley asked him questions. Grassley said, hey, did you ever authorize someone at the FBI to be an anonymous source? He said, no. Then in September 20, Ted Cruz asked him the same question and he reaffirmed it. He said, I said the truth back then. The answer is no. Now, in the September 2025 federal grand jury, in 2025 this year, of course, a federal grand jury indicted him. 2 counts, 1 count lying to Congress, the other count obstruction of Congress. After the indictment was returned, the government filed a motion seeking judicial assistance in implementing a filter protocol because this guy was a lawyer. Now, during subsequent litigation related to the request, as well as a motion filed by Comey seeking access to those grand jury materials again, the assigned magistrate judge raised concerns about the Fourth Amendment issues and Comey's privilege, saying, wait a minute, you searched his emails related to a different case, which was an FBI leak case. And now you're prosecuting FBI Director Comey? That was a separate warrant for a separate matter. And he's a lawyer. So you can't use this evidence. Who began to represent Comey shortly after his termination, of course, Daniel Richmond. Now, the indictment was subsequently dismissed. The court came back down and said that Lindsay Halligan, who presented the indictment to the grand jury, was improperly appointed and the case got dismissed without prejudice. So, of course, we can refile it. But the question is, will they? Now, Comey informed the DOJ Inspector General that he didn't consider his having directed Richmond to provide info to the New York Times to be privileged. Wow. So that was not privileged, and that he didn't intend to assert any kind of privilege about any direction to Richmond. So cancel that part of this. Now so the judge will then have to hang their hats back on the invalid search warrant. Now you used the wrong search warrant to go get the evidence versus you can't use the evidence because he's his lawyer. So they say, well, Comey never intended it to be privileged and be used by his lawyer. So now you're just going to rely on your fake warrant excuse. So shortly after the indictment was dismissed, okay, he goes to get his evidence back. It's like a drug dealer going to go get back the drugs and the paraphernalia. We like to take all of our meth back now. Since he got dismissed, I don't want to get charged. Can we have all the drugs back? Richmond filed a motion to this court. He wanted a return of property under the federal rules of criminal procedure. He said, I need an order. Give me back my emails, saying the government must immediately return or delete certain materials. They cannot use we read all the emails here, as well as any of the copies thereof. They want a temporary restraining order. They want to stop the government, the prosecution, from accessing any of this stuff and delete it all. Now, 1 week later, after this got filed, Richmond sought a temporary restraining order, stopping the government, stopping the Eastern District of Virginia, U.S. Attorney's Office, from searching, using, or relying in any way on the materials that were seized. And so Comey has no evidence. You can't prosecute him because all of the evidence that had him dead to rights can't be used. The next day, without awaiting a response from the government, this is how scummy these judges are, the lower level court didn't even wait to hear from the other party. So how fair is that? Fair, neutral, nonpartisan judges, no bias at all. Oh, you want your emails back? Yeah, here you go. The court issued an ex parte, okay? Didn't even tell the other side. Instantly hit a TRO that granted in part and deferred in part what Richmond wanted. The court ordered the prosecutors to, quote, identify and segregate and secure any of his personal computer information and his Columbia University email accounts and his iCloud account, as well as any copy of those files, any materials extracted from those hard drives and elsewhere. Now, the court further ordered the government, do not access any of the evidence that might be damning for them. And you must segregate it out and do not look at it again. Now, under the rules, they say, Judge, you know this one. An adverse party to a TRO, like if you're going to enter an order stopping us from doing something, if you issue that without notice and you didn't even tell us about it like you did, we can appear and move to dissolve that order. Now, on a motion to dissolve a TRO, the party that got the order bears the burden of showing that it should exist. To obtain a TRO, we know the rules: likelihood of success, irreparable harm, balance of the equities, public interest. Now here, the government is the opposing party. And what happened here is ridiculous. Their motion from Richmond is a collateral and it's a premature. It's really a motion to suppress evidence. It's thinly veiled as an attempt to return property, but it's really in benefit of James Comey. It's a civil case brought by Richmond. Can I have my property back? But it's really going to eliminate the prosecution against James. This is how they work together in these sneaky operations to insulate each other. And the judges just, yep, get your property back. Now what? Lindsay, not even the criminal case. It's just a civil case to seize the evidence, saying here, It's masquerading, great word, as a motion for return of property. Now, it is impermissible for this court to enjoin a criminal investigation, to stop us. There's a potential prosecution right here. You're not allowed to restrain the use of evidence to benefit some other third party, in this case, Comey. For those fundamental reasons, you should deny his motion. Now, the rules say under Rule 41G, this is what Richmond is invoking to get his emails back. He says a person aggrieved by the unlawful search of property may move to get those properties back. Now, the motion must be filed in the district where it was received. You must receive evidence. If you grant the motion, then the court must return the property, but there could be conditions on it and more. Now, as the D.C. Circuit Court of Appeals has explained, writes Trump's DOJ, Rule 41 allows the owner of the property that the government has seized in a search to seek its return. And while this rule does exist, it is for one purpose. It's the return of property. And some attempts to get stuff back is improper. And the courts have already adjudicated this to say that there are actually improper suppression motions that are being used to seize evidence. Now, continuing, they say to determine whether this is in fact a disguised suppression motion, the court must look beyond the mere effect of the motion. What is the true purpose of it? The court needs to dig into this. Is this really about a return of property, or is this really about suppressing evidence? We have to go through some factors like this. What is the probative? How do we probe the purpose? Why do they need the property? Is the government going to need this at some future hearing or trial? So we'll go through these factors and weigh it out. Now, in sum, all said and done, the question is whether the motion seeks not just the equitable return of the property, but whether ultimately they're just trying to suppress evidence, in this case, the Comey emails that would be devastating to him. Now, Richmond and his misguided use of the rule is leading to doctrinal and conceptual errors. Now, fundamentally, the motion conflates Fourth Amendment standards with those applicable to Rule 41 motion. So one's like unlawful search and seizure. One is the return of property as a result of that search. But they are different. If a criminal defendant objects that evidence was seized in violation of the Fourth Amendment, motion to suppress that evidence is proper. You got that evidence illegally. You didn't have a warrant to enter. You made up some exigent circumstances that didn't hold muster. Whatever you seize from the house now gets suppressed. If a property owner claims an unconstitutional seizure, however, he is not necessarily entitled to its return if the government still needs that evidence in its prosecution. Now, this rule was never created to deny the prosecutors the use of evidence. And it's not an expansion of the exclusionary rule, right? One of the things that we do in criminal law when the government screws something up, if they violate your rights, is we say they can't use that evidence. Because the government has all the money in the world. You know, they're not like, what is the sanction going to be against the government? You're going to fine them with what? Your taxpayer dollars? They don't care. You're going to fire them? No, of course not. They never get fired. So what do? You suppress the evidence. If they got the evidence in violation of your constitutional rights, you can't use the evidence. But that doesn't mean you get the property back. It just kind of goes to the validity of the criminal charges. Like if they seize the drugs, you don't necessarily get your drugs back if your case gets dismissed. Now, that's so because the return of this property and the exclusionary rule are different purposes. Okay, suppression of evidence helps ensure that law enforcement personnel follow the rules, because if they don't, they can't use the evidence and their case gets dismissed. That's the only thing that really matters to them. Everything they're working on, this entire case, gone. That's the penalty. And the government that they serve. But Rule 41G is about property and privacy interests. And suppression of that evidence only applies to criminal defendants where the class of the aggrieved is much broader, not here. So consequently, this rule avoids an all or nothing approach whereby the government must either return the records or make no copies at all. And the rule contemplates keeping copies of evidence and more. Now, in this case, Richmond has sought what is in effect a suppression. Okay, these are copies of emails. It's not like he wants those emails returned to him. He wants the government to not use them, which is suppressing the evidence. Here you go. You got the emails. You probably still have your copies in your account. You're trying to stop us from actually using the evidence to protect your BFF Jim, and seeks to prospectively enjoin the government from conducting a criminal investigation. Now, he has not carried his burden of demonstrating his right to the property's return. He's not even seeking the property's return. How do you return emails? Instead, he is seeking the destruction of the materials because he doesn't want it to be used. Now, when you consider all of that, this is not a proper return of property motion at all. It's an indicator that this is a motion to suppress, and he shouldn't be able to bring that claim here. And so accordingly, as the DC Circuit Court has explained, even in the face of a property return motion, the government can reasonably retain evidence. If there is an ongoing investigation or trial, we're allowed to seize these things, and the courts may rightly refuse to return this property if the government needs it for its pending investigations. Now, underscoring the same theme, they may not use a civil lawsuit to attack a criminal prosecution, which is exactly what Richmond is doing. The Court of Appeals has also applied this reasoning to hold that this is impeding a duly appropriate function of the executive branch. And if you want to challenge your crime, you challenge it in the criminal process. Congress has established a comprehensive set of rules called the Rules of Criminal Procedure, and you cannot bring a parallel case in an ancillary proceeding to circumvent federal criminal law. Now, even when the plaintiff is not personally the prospective criminal defendant, same basic logic holds, and Richmond can't use this on behalf of Comey. Now, if we apply these principles, all that said and done, it is clear that Richmond's motion is not a valid or meritorious motion for return of property. It is a motion to suppress James Comey's case. That is improper multiple times over, and so the court should deny the motion and dissolve this TRO that we never even got to be a part of. You issued it on an ex parte basis. We couldn't even see it. Now, Richmond does not genuinely want any property back at all. After all, the government has copies of his emails, yet he sought an order directing the government to immediately return and to immediately delete what he says were illegally seized and retained evidence. He wants all copies gone, and the judge is giving it to him. Now, moreover, he also sought and obtained an order that stops the government from relying on or reviewing any of the evidence against him, saying you can't use it. And his request is that copies of the seized documents come back to him. And it essentially is suppression of the evidence, not a return of property. Now, Richmond, therefore, is not bringing the appropriate claim. If you grant his motion, it will have the effect on the presentation of evidence at a future trial. And he expressly, in his request, asks that the government be barred from using the evidence if Comey is indicted again. Specifically, if you want to charge him, don't use my emails. And the judges are like, yeah, great argument. Now, the close connection between the Comey prosecution is also demonstrated by the timing of his motion. He does not even remotely explain why he didn't try to get these back before. In fact, the Arctic Frost investigation closed in 2021. He didn't go get his emails back. It was a friendly FBI back then. But the timing of this makes perfect sense. Just think about it. Once one recognizes that this motion is a suppression motion aimed at helping his BFF Comey. If Comey is reindicted, can't use his emails, Comey walks. Now, if Richmond is flatly mistaken that any charges related to this conduct are time barred simply because the district court held that the prior indictment was void as a result of an appointment defect, is not accurate. The statute of limitations has expired on the charges with which the grand jury indicted Comey, but the savings clause, section 3288, expressly allows the defendant to be reindicted whenever an indictment charging a felony is dismissed for any reason after the period. We got 6 months to bring it back. So given that Richmond has all but conceded that he seeks a suppression remedy, he doesn't care about his emails, he just wants to save James, directed at a future prosecution, it would be unreasonable for the court to allow Richmond to collaterally secure that result, to seize evidence that would be damning to Comey. Again, the rule is not intended to prevent the government from using the evidence, even if it was unlawfully seized from that one person. We don't have to not use it. Advisory committee's notes all explain this in more detail. Now, and it cannot be seriously disputed that the materials that Richmond wants or returned or destroyed are relevant. We're going to be using them. We already said we were going to be using them. Indeed, that's exactly why Richmond wants the government to destroy the copies. If you have the copies, Comey's in trouble. That is a remedy that he can't seek. It's clear under governing law that courts may refuse to return claimed property if there is retention by the government pending a future trial. So that will be the case here. If the government does obtain a new indictment of James, if that does transpire, Comey will be free to move to dismiss that new indictment or seek suppression of this evidence once this comes back. Now, to be clear, the government denies that there has been any violation of the Fourth Amendment at all, but we reserve the right to fully litigate that. Now, Richmond, he says the government erred by using evidence properly searched for and seized for other crimes, right? They were looking at classified information and national security types of crimes for Richmond, and then Comey got hit with different charges. Okay, so they're saying, well, the original search warrant that led to the discovery of these emails was for a different set of crimes. Comey's got a different set of crimes than the original search warrant, so you can't use it. They say that's not the law at all. That is legally mistaken. There is no reason why property seized under a valid search warrant, then thus lawfully obtained by the government, may not be used in the prosecution of another crime where you discover, oh my gosh, there's a whole separate set of crimes over here that we've discovered based on these emails. Now, even if there were a Fourth Amendment violation, it's clear under governing law that even the presentation of this evidence to a grand jury wouldn't be sufficient to dismiss an indictment. And there's no equitable relief that Richmond can be entitled to here. And finally, Judge, it would be unreasonable, writes Trump's DOJ, for the court to grant Richmond the prospective relief he requests. That is, a permanent injunction that would stop the government from making any use of the emails. Because if you grant that relief, you're going to allow a civil litigant, somebody just suing to stop the whatever. We've seen a lot of that over the last 10 months, 11 months. They can attack a pending prosecution. If you grant Richmond this injunction and you bar and you permanently enjoin the government from making any further use of these materials, that is going to stop the DOJ. And just think about the precedent this will set. They'll all just sue. Oh, well, Trump has evidence that John Brennan is a traitor. Well, John Brennan can just sue. How'd you get my emails? Give me those the emails back, and a federal judge will just say, yeah, I can't use that evidence against them. So the DOJ is fighting hard. For all these reasons, the court should deny his motion, dissolve the TRO, because by issuing it, the court effectively stopped the government from conducting its criminal investigation and a potential prosecution. He's also not going to win. This is an impermissible collateral motion to suppress. We're not going to destroy relevant evidence. Richmond is not going to suffer any irreparable harm if it's not destroyed. Using these materials to prosecute Comey if he is re-indicted again is not a harm to Richmond at all. And being called as a trial witness and questioned about these materials isn't a harm either. He can also bring a Bivens claim. Moreover, the balance of the equities here doesn't favor Richmond since he's seeking extraordinary equitable relief. And this doesn't serve the public interest either, since granting Richmond's request would be an impermissible intrusion by the courts that could hinder the executive prosecution. Look who is on the signature page here, my friends. You see that right there is the Deputy Attorney General, Todd Blanche, in conjunction with Lindsay Halligan, Robert McBride, and they're bringing out the big guns, the deputy AGs here, saying, how dare you allow a civil litigant to seize evidence in the middle of a pending criminal prosecution? And Daniel Richmond is enacting a force field around James Comey. The DOJ is responding to dig into it, but meanwhile, we've got other people like Pencil Neck Adam Schiff, who is saying they didn't do anything wrong. And maybe it'll be harder to prosecute him if the judges allow all of the evidence to be seized by friendly allies.
He talks a lot about Russia, hoax. Did you get anything wrong about that?
No, I don't think we got anything wrong. I do think that at the end of the investigation, Mueller concluded, and I said, throughout the investigation, Robert Mueller, I said throughout the investigation, this was very possible, that he could not prove the crime of conspiracy beyond a reasonable doubt.
He talks a lot.
Yeah, so we'll, of course, continue to see what happens with the Comey case, but the DOJ is now trying to get their hands back on the evidence that a federal judge just took away from them. And we also have questions about whether there will be a new appointment of a special attorney to pick up these prosecutions. The Letitia James grand jury returned no bill. They did not indict her for the second time. We'll see if they do a third time. We'll see if they appeal the disqualification order of Lindsay Halligan. But we are in the middle of a full-blown judicial coup, as we can see right here. Other judges breaking all precedent to allow co-conspirators to come back and seize the evidence to protect the deep state operatives, guys like James Comey. So we're going to keep our eye on this one, my friends. Thank you for subscribing and joining as we do. All right, now let's turn our attention over to this other lawsuit against Gavin Newsom. Gavin Newsom and the Californians hit with a major lawsuit from the Trump DOJ. This one about illegal aliens getting in-state tuition, scholarships, and subsidized loans. And the DOJ coming out saying, we're not going to be allowing this to happen. And the lawsuit is being brought by the Civil Rights Division. And you see, this is what it looks like right here with a bunch of familiar names on it, including Stanley Woodward Jr., the associate AG, the guy who was representing Walt Nauta in the Florida classified documents prosecution of Trump, who was ensnared in a scandalous attack by Jay Bratt, the Florida Oompa Loompa prosecutor working for Jack Smith, who tried to convert him to get him to flip on his client to create a fake false confession that would then enable Stanley to become a DC judge. He, of course, didn't do that because he's got integrity. Now he's the associate AG. What's up, Stanley? So they're all out here from the Civil Rights Division saying, how about no scholarships for illegal aliens? How about that money goes to American citizens? That seems like it might be a good idea, but this is California we're talking about. Now they're being sued from the DOJ, saying, all right, California, wake up. Federal law prohibits aliens who are illegally present in the United States from getting in-state tuition benefits that are denied to out-of-state citizens. So if you're going to give them a discount, you got to give it to everybody. Now, there are no exceptions. See 8 U.S. Code 1623, subsection A. But California Election Code, they extend eligibility for in-state tuition benefits at post-secondary educational institutions, including resident tuition, scholarships, subsidized loans. They give it all to illegal aliens. Yeah. And they, no, we're not giving them free healthcare. Yes, you are. We're not giving them free education. Yes, you are. Look, while requiring U.S. citizens from other states to pay higher rates. Now, this unequal treatment against American citizens is squarely prohibited, and it's preempted by federal law. It expressly provides that an alien who is not the law, quote, an alien who is not lawfully present in the United States shall not be eligible on the basis of residence within the state. Can't have it unless you're a citizen is also eligible for the same benefit. So you can't give illegals a windfall at the expense of Americans. Now, accordingly, since we know what the federal law says and California law is not in compliance, their law is unconstitutional under the Supremacy Clause, and now we're suing to eliminate it. Now, defendant Gavin is a governor there who's running for president. He just made a new stupid book release video. I'm Gavin. Let me tell you about my American dream, but how I sleep with my campaign manager's wives and all these things. Newsom is sued in his official capacity as an ex officio member of the Board of Regents. We know who Gavin is. Who else is being sued? Rob Bonta, AG of California, UC Regents, trustees, Board of Governors, and more. Now, as we know, the Constitution of these United States, Gavin doesn't really care too much about. It empowers Congress to establish a uniform rule of law of naturalization. Article 1, Section 8, Clause 4. Congress writes the rules. And they can also regulate commerce with foreign nations. Article 1, Section 8, Clause 3. Right next door. The Constitution also vests the President of the United States with executive power and to take care that the laws be faithfully executed over in Article 2. Now, the United States has well-established preeminent and preemptive authority to regulate immigration. The authority comes from the Constitution. We've also passed statutes to this effect, and Trump has come out with an executive order. He came out and he said, to the maximum extent permitted by law, no taxpayer-funded benefits go to unqualified aliens. That was earlier in the year, February. Then in April, boom, Trump hits another one, protecting American communities. And we're going to take appropriate action to stop the states from creating sanctuary dumpsters. Now, these orders emphasize that federal and state governments must not grant greater benefits to illegals than they give to American citizens. That sounds pretty obvious in a country called America, but that's debatable in certain cities now. They also reflect, because in some cities like LA, they've got like 2 million illegals, or in certain places in Minnesota, the whole community is immigrants or illegal immigrants. They also reflect Congress's intent expressed in multiple provisions. We want to reduce incentives for illegal aliens coming to our country. In fact, in 1996, Congress passed this bill called the Personal Responsibility and Work Opportunity Reconciliation Act, PRWORA. They also passed this, the Illegal Immigration Reform and Immigration Responsibility Act. What we wanted in those acts was self-sufficiency among immigrants, not illegals who come into the country and then demand they be put up in the Roosevelt Hotel, have housekeeping come by once a day at least, get health care cards for their illegal children, and food cards. Limit their dependence on public assistance. Yeah, and that has dramatically changed, right? When many people's lineage got to America, it wasn't in the same vein as what it is now. A gigantic social safety net that has to take care and feed everybody and house everybody. Congress declared that aliens within our borders should not depend on public resources. Rely on your own capabilities and your own resources, and go back to your own countries. Saying, moreover, Congress determined it's a compelling government interest. We need to remove the incentives for illegals. Now, as relevant here, a state may provide that an alien who is not lawfully present is eligible for any benefits if they would be ineligible only through the enactment of a state law after 1996. Okay. Even in such cases, a state may not offer in-state tuition if you're here illegally, if those same benefits are denied to other U.S. citizens. You can't give illegals a windfall. In 2001, California said, oh, yes, we can. Watch us. They passed California Education Code 68130.5. That law unequivocally enables eligibility for resident tuition in an institution at the state for illegal aliens. Okay, they say, perfect. Yep, if you're an illegal, non-citizen, we'll pay for you. As long as you attended a high school or a California equivalent for 3 years. If you graduated from high school, if you are enrolled in a post-secondary education system, or if you filed an affidavit to legalize his or her immigration status, and you say, hey, I'm working on it, they'll accept you. So notably, students between the age of 6 and 18 must attend a high school in the district where the guardian is located. Now, in 2014, then California came back out. They passed another bill which said, okay, well, we're going to cover you if you graduate early in advance of the 3 years. Then in 22, they amended that and they deleted the part that said 2 years at another location. So constantly, now each of these three governing boards adopted rules and regulations, and all of this allowed illegal aliens to qualify for the exemption from non-resident tuition, cheap schools, and tuition costs for illegal aliens. Now, pursuant to the law, the UC regents have adopted a policy that establishes criteria for the purposes of assessing tuition rates. The regents set resident tuition rates significantly lower than non-resident tuition rates. If you live in California, you pay California state taxes, you get essentially cheaper and subsidized housing because you're paying taxes into the system. But if you're an out-of-stater, you're not. You got to pay the higher price. Now, the University of California post-secondary education institutions are responsible for determining in-state or out-of-state status. An individual seeking in-state status has to prove it. And there are procedures for proving this. Now, here's how you can prove it. Proof of attendance at a high school, 3 years here, proof of graduation or the equivalent, an affidavit. If you're present illegally, then you have to submit some affidavit saying, well, I'm working on being not illegal. Under their policies, an illegal alien who meets the requirements of this is eligible for a waiver. So they get non-resident tuition, right? A waiver of non-resident tuition. You have to pay the higher fee unless you get an exemption. They get exemptions. Therefore, illegal aliens who satisfy those criteria get reduced benefits. Now, unless a student qualifies for special circumstances or is otherwise exempt, there's a higher rate. And the treatment of illegals stands in stark contrast to how they treat U.S. citizens. That's exactly right. Now, pursuant to the laws, they've adopted policies, and again, resident tuition rates much lower. An individual seeking in-state status for the purposes of assessing resident tuition bears the burden of proof. The trustees allow this to happen, and more explanation about how this works. Same thing is happening for community colleges. Regulations say you got to go this way to do things, but all these people get benefits for all of these things. So community colleges, University of California, other relevant California laws. So all of the different educational systems sounds like are getting thrown into this grift. Now, similarly, that's for California state. We see the California Dreamers too. Then in 2011, California passed another bill, the California Dream Act. And in 2014, once again, the Dream Act subsidized loans to illegal aliens that are exempt for paying tuition. In fact, interest will not even accrue on these loans so long as they're enrolled. This program is not available for U.S. citizens who are not exempt for the non-resident tuition. So all of your money going to more illegal subsidies. Now, the Constitution Supremacy Clause says that our federal laws supersede your state laws. Express preemption occurs when Congress is express about it. Federal statutes may preempt state laws and render them ineffective. And they may do this by declaring the intent on the face of the statute. So they pass something that's in direct conflict, it's nuked. Under the Supremacy Clause, we win. And when the federal statute here, lots of law here, the law contains an express preemption clause. It literally says, notwithstanding any other provision of law, an illegal alien shall not be eligible on the basis of residence within a state for discounted rates unless every other American citizen is. It's in the law. It's very explicit. At least 3 other courts have found that this law does expressly preempt this in other cases. Fifth Circuit, Eastern District of Virginia here, Arizona Court of Appeals. It's been all over the place. Even just happened in Texas. The court found that this section expressly preempts state laws. You can't give illegals better benefits than citizens. And similarly, even in Oklahoma, they figured it out over there. Expressly preempts Oklahoma laws to give discounts. So therefore, you are also preempted, California. The fact that your law does not specify that a student must be a California resident in order to get an exemption doesn't change the analysis. You've got a bunch of reasons why you can exempt them, but the only one that we care about is the one we're fighting about. You can say, well, other things make them have to be residents, but that's not what we're arguing about. Because the California Dream and Dream Loan Acts provide scholarships and subsidized loans for illegals that are not offered to U.S. citizens, they are preempted. Federal law says that's illegal. Neither the scholarship nor the loan program is available to non-California residents, only to illegal aliens. So they're preempted. And so we're suing. We want a declaration that there is an actual controversy, and we're suing you now for several counts. 1, violation of the Supremacy Clause. Our laws override your laws. You are directly conflicting with our laws, and so you need to stop handing out taxpayer dollars to illegal aliens. Judge, we ask that you enter a judgment declaring that their provisions violate the Constitution and the Supremacy Clause, and that this court issue a permanent injunction to stop this money from going out to non-citizen illegal aliens in the state of California. So Edward A. Olson, Civil Chief, Assistant U.S. Attorney, Eastern District of California, sending that one in here. And for some reason, the Democratic Party is very much in favor of additional benefits for non-citizens that average citizens don't get. Remember, they get extra privileges, hotels, cell phones, food cards, healthcare for their kids, free education for their kids, looks like scholarships for education, all of that. But in addition, if you're a human trafficker like Kilmar, Wifebeater, or Abrego, you'll have senators come visit you when you are deported. You'll have the FBI exonerate you while you're trafficking people across the state of Tennessee. You'll have Tennessee Highway Patrol fine you driving without a license, without registration, speeding, having people unsecured in your passenger compartment. All of these problems, Tennessee police, oh, keep going, no problem. FBI, no problem, keep going. California, no problem, have a scholarship. Our country's being hollowed out by the very people who are put in charge, and it's a sick thing to watch, and we're getting pretty tired of it. But here is Eric Schmidt, a senator, who shared this. He says, hey, no big deal, just a congressional Democrat were asking about this. I think this is capsized Guam. He thought that an island was going to capsize. He still has his he, him pronouns on there in case you had any doubts about it. But he called America the great Satan. And he's saying that, essentially Trump is kidnapping people off the streets. And this is resulting in language like this from the Democratic Party, Mr. Capsize himself.
Yeah, we are the world's #1 bully. And we're using our immense, unrivaled power to rule over those who have less power. And we're doing it with impunity. And this sends a shocking message to the world that America is indeed what did they used to call the great hand of Satan or something like that? I mean, America under the Trump regime is demonstrating that moniker was entirely accurate. The great Satan. That's what we have become in this country.
Okay, so that's Mr. Capsize himself, and I've got that clip here queued up just so you can see the caliber of intelligence that we're dealing with. This is the same guy, Rep. Hank Johnson, talking to somebody in the military about Guam after I think a hurricane struck it. He was a little bit concerned that if we send resources and support to the island and like put a bunch of boats on one side of the island to like unload water and food and supplies, well, that could cause a big problem over there. Here's what Hank had to say.
From shore to shore, and at its smallest level, or smallest location, it's 7 miles between one shore and the other. Is that correct?
I don't have the exact dimensions, but to your point, sir, I think Guam is a small island.
Very small island, about 24 miles, if I recall, long. So 24 miles long, about 7 miles wide at the least widest place on the island, and about 12 miles wide on the widest part of the island. And I don't know how many square miles that is. Do you happen to know?
I don't have that figure with me, sir. I can certainly supply it to you if you'd like.
Yeah, my fear is that the whole island will become so overly populated that it will tip over and capsize.
We don't anticipate that.
Yeah, don't anticipate that. And that admiral was doing a nice job of just not laughing right in his face, saying the island might flip over. So that's who we're dealing with. He thinks America is the great Satan, and he doesn't have to stay here. He can, of course, go to another country if he cares to. But here's Gavin. He's coming out. He's saying, are there even going to be elections? Trump is such a fascist that he might stop the elections from happening, which is rich coming from these people who tried to throw him in jail and throw him off the ballot.
I completely believe that this notion of fair and free elections, that issue is the issue that will define the 2026 midterm in the context that question is on the line, whether or not there'll be fair and free elections going forward, even in 2026. And I made that point on election night with Prop.
Free and fair to them is their political opponents have 4 felony indictments in multiple locations and are thrown off the ballots because of a fake insurrection conducted by the FBI.
50. And there's all the signs and evidence, and I could stack 5 specific examples from the BORTAC teams to the private secret police that he's putting out there, the fact that he has quick response teams in all 50 states for the National Guard, the fact he's going after the integrity of vote by mail, the fact that he's got DOJ monitors out there, and the fact that he's rigging the elections as it relates to the strategy with the redistricting.
Wow, he better be careful. He'll get indicted for being an election conspirator, an election denier. Oh my goodness. That all sounds like good news. We should have election monitors to monitor the rigged elections in sanctuary dumpsters like California, where it's a one-party state. He's worried about free and fair elections. Give me a break. All right, so here's the president talking about Somalia and what a garbage country that is. He said, I want to see people that contribute. I don't want to see Somalia.
I want to see people that contribute. I don't want to see Somalia. I don't want to see a woman that, marries her brother to get in and then becomes a congressman, does nothing but complain. All she does is complain.
She does.
And yet her country's a mess. It's one of the worst in the world. Let her go back, fix up her own country. Somalia, and I was right about it. I started complaining about Somalia long before the scandal. The horrible things they're doing to Minnesota, it's incredible. They have an incompetent governor there, too. The Democrats are running some bad ships. I want to see people.
Yep, and they are. And they're standing by illegal aliens at the expense of their own citizens and constituencies because that is where they're drawing their political power. No other explanation for that. And we're excited to see the DOJ keeping the pressure on them. Of course, the DOJ has filed a bunch of other lawsuits that we've covered here and will continue to, like demanding voter lists from all of the states as well. We want integrity in our elections. We want integrity in our finances and our citizenry. And so once again, Civil Rights Division suing California. We'll keep our eye on this one. All right, now, my friends, let's turn our attention over to the Maxwell matter, starting right here. The Maxwell files now ordered released. We see the opinion and order came down from the Southern District of New York, judge named Paul A. Engelmeyer, and this was after a back and forth over whether to release the grand jury materials. And we see that there were some letters that came in. Of course, Ghislaine Maxwell's still alive, and she has an opportunity to object to these files being released. She has thus far not done that, said she has taken no position. And so the prosecutors have also sent in additional letters. They sent in 3 letters from victims and witness coordinators, and we got the victims' opinions as well about whether this material should be released. So the judge considered all of that and then issued the order, and here is what he says. All right. This decision resolves a motion pursuant to the Epstein Files Transparency Act. The DOJ wants these files released. They say, we want an order that would allow us to publicly release 2 categories of records that they say are within the scope of the act. And the judge is going to grant this, but he's going to explain what's coming out soon, and we'll see what's inside. Now, first, the DOJ asks the court to rule that the act covers grand jury transcripts and exhibits in this case. He's going to call it the grand jury materials. So transcripts from presentations to a grand jury that would lead to an indictment, and any exhibits. They say these override the rules. Criminal Rules of Procedure Rule 6E says you can't disclose any grand jury materials because they're all super secret. But that ruling, if the judge grants it, would authorize the DOJ to drop this stuff out to the public. Now, second, the DOJ also asks the court to rule that the act also covers extensive discovery that the prosecution provided to counsel for Ghislaine. Now, that is going to be a lot more than anything in the grand jury materials. And we've covered other battles about this before. Remember, this is the second time they've asked for these to be unsealed. And the first time around, the judges responded, and there's nothing even in there. The presentation to the grand jury took like 90 minutes, like 60 minutes. It was one witness and a set of slides. Like, that's all it was. So what's in there? Now, that's different than the discovery. Okay, that's a back and forth. That's going to be a gobs more evidence. Saying we want that too, and modify the protective order that they entered in the case to release it. The modification would permit the DOJ to also release the discovery. Much more there. Now, consistent with this act, the DOJ has pledged they're going to withhold or redact segregable portions that contain personal information, and other victim information will not come out. Now, for the following reasons, the court grants the motion. In modifying the order, we also put in place a mechanism to prevent the victims, and we're releasing it. Here's some background. Now, the history of this case, spanning indictment through direct appeal, is set out in a prior decision. And then we know how this went down. In fact, on June 29, 2020, a grand jury indicted Gouveia on charges arising from her facilitation and participation with Jeffrey to abuse multiple minor girls. On March 29, 2021, a different grand jury came in and indicted her again. They added additional related charges. So we've got two sets of transcripts, or a set of transcripts, two transcripts. Maxwell's jury trial commenced on November 29, 2001. We covered it at length here. It entailed testimony from four women who all described the abuse they had suffered at the hands of Epstein and Maxwell. So the four women came out, didn't identify anybody else. Maxwell and the grand jury presentation didn't involve anybody else. It was the four women. Testimony of individuals who worked for Epstein and Maxwell. We heard from the pilot. We heard from the housekeeper. Testimony of law enforcement officials, physical and documentary evidence, Maxwell and Epstein's black book, flight logs of the private planes, FedEx records, and more. Now, the trial ended a month later. She was convicted 5 felony counts and conspiracy to entice minors, conspiracy to transport minors, transportation of minors, participation in trafficking, and trafficking. Bunch of charges. After resolving these motions, the judge, Allison J. Nathan, who then got appointed, she got a promotion. She went up to the, I think, Second Circuit Court of Appeals. They sentenced Gouveia to 240 years in prison. Maxwell appealed. She said, hey, Epstein's original non-prosecution agreement, his original plea deal, included co-conspirators. She says, that's me. She appealed it. Court of Appeals affirmed her conviction, asked for a rehearing, denied, went to the Supreme Court, denied. So she's sitting in custody. She's now waiting a pardon. Now, on July 18, 2025, the DOJ moved to unseal the transcripts and exhibits. They said, there's a bunch of public interest in this. And we read through the motions here. We're like, yeah, they're trying really hard. Now, the case was then assigned to this judge. Between July 29 and August 8th, the court received submissions on the motion. These included the grand jury transcripts, which the judge says I looked at. There was also a DOJ letter identifying other portions of the materials that were not already in the public record. So we've seen a lot of this. There was a brief from Maxwell. In the first attempt, she opposed it, and the victims also sent letters in. Then on August, the court denied the motion. Sorry, you can't get anything. We're like, oh, well, there we go. The court held that the criminal rules of procedure prevented it from coming out. There are special circumstances doctrines that we could rely on, but those didn't apply. They said, first of all, the grand jury materials, look at this. They say the DOJ wanted an exception the first time around, but I looked at it and I decided it's not going to reveal new information of any consequence. Nothing in there. There's no new information of any consequence. The DOJ's entire premise that the materials would bring to light meaningful new information about these crimes is demonstrably false. Do we know why? Of course we do. It's because Maureen Comey was the person prosecuting the case. She was part of a mop-up operation. Then Epstein was eliminated or whatever, and case was closed. On the contrary, the grand juries had met briefly, each receiving evidence on a single day. They had not met to investigate, but solely to return an indictment. That's it. The only testimony that they had heard was summary testimony from 2 law enforcement officials. And with minor exceptions, the evidence before the grand juries was already a matter of public record, largely as a result of Maxwell's trial. So the premise that the DOJ gave to invoke a special circumstance doctrine to unseal the records was not accurate. It was false, saying it's disingenuous. There's nothing new in here. I read it. Second, even if the doctrine did apply, another multi-factor test said we shouldn't disclose it. Among the factors opposing disclosure the first time, the materials were quotidian. They were not significant at all. Nothing even in there. DOJ's position in support of disclosure deserved limited weight, given its false premise and irregularities. So the DOJ was not trustworthy. The DOJ did not seek tailored disclosure, but they said, release it all. And the systemic interest in grand jury secrecy would be harmed. So he says, I had a good reason not to release it back then, but now I do. The DOJ did not appeal. It was all just a token effort. We read it. We're like, okay. Todd Blanche wrote both of those. He's like on a note out at a restaurant. He's like, oh crap, I got that motion for Epstein and Maxwell. Writes it down, sends it in. So they're like, no, we're not going to release it. So then November 19th, Congress nearly unanimously passed the president signed Epstein Files Transparency Act. Dun, 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 dun. The act's operative section, called Section 2, requires within 30 days a release of the files and a bunch of other materials. All investigations, prosecutions, Ghislaine Maxwell, flight logs, anybody with civil settlements, any entities, any immunity deals, any internal communications, emails, all the things, all memoranda, directives, anything misplaced, documentation of his death, autopsy reports. Nice list. We like the list. Something here under subsection 2B, prohibited ground for withholding. They say you cannot withhold this, okay? No record shall be withheld, delayed, or redacted on the basis of embarrassment or reputational harm or anything. Release the files. Then we got this, subsection 2C. There are permitted withholdings. Some stuff does not have to come out. If it's personal information, if it would clearly constitute an invasion of privacy, those should be redacted. Within 15 days of reviewing the materials, submit your proposed redactions, and then we'll make a decision courtesy of Congress. So they say, send the redactions over to Congress, over to the judiciary committees, and let us know what you're not giving to us so we have notice about it. Now, then, November 24th, the DOJ moved for an expedited ruling. They said, hey, we're back. Can you please unseal all the transcripts and the exhibits? We'd also like you to modify this so we can disclose all of the other materials. They cited the protective order that Judge Nathan issued before. She's, of course, on the Court of Appeals now. The DOJ stated that it interprets the act to reach everything. We need to release everything. So we're asking for your permission to do that. They didn't say that they would withhold anything else, only what is ordered under the law. So then on November 24th, after they got the DOJ motion, the court, mindful of the act's 30-day disclosure deadline, set an expedited schedule for responses. Maxwell responded. It set the same deadline for the victims, told the DOJ to notify them. Then in November, issued a second order. The court's review of the docket had revealed that 2 protective orders had issued in the case. The first one came out right after the arraignment. Second was issued 5 days before trial. Everybody got fair notices of this. And so the court said, do you want us to unseal both of those as well? The DOJ responded. It said yes. Both orders. The second order subsumed the first order, and we want everything. The DOJ said, we will withhold victims' information pursuant to the law, but otherwise release it. Now, as to the categories, the DOJ listed the following. They said, we're going to be releasing all of these things. Judicial process, warrants, pen register orders, related applications, financial records, bank records, credit cards, checks, all the things, travel records, airlines, private airline flight logs, online booking records, manifests, grand jury subpoenas, Instagram, Microsoft, Google, records obtained from any agencies, Bureau of Prisons, New York State, Virgin Islands, NYPD, Delaware, school records, search warrant returns from ISP providers and all, materials that went over to law firms, arrest reports, statements, photographs, civil litigation, other photographs of the properties, immigration records, records related to online purchases from online retailers, materials from the Palm Beach Police Department, Southern District of Florida, forensic examinations, postal courier records, DMV records, all of it. Then on December 3rd, not long ago, Maxwell, through her lawyers, responded. Her one-page letter stated no position on the unsealing. Then we got another letter. On December 2nd, Annie Farmer, she testified using her real name in the trial. Shout out to Annie Farmer. Miss Farmer's letter stated that she supports, subject to redactions of personal information, the unsealing, as well as all of the investigative materials. She expressed concern the DOJ might not fully comply with the act and disappointment that, To date, the DOJ has not taken action against other critical inner circle Epstein accomplices. And of course, our question is always who? And has she identified anybody else who would be the subject of that? If so, we would like to know that. We'd like to know that she has absolutely done that, and ask who received that information and what is the status of that investigation? Or is she just presuming that there are other people? Because thus far, we haven't seen really any evidence of it at all, quite frankly. A lot of rumors and suspicion about it, but no files have been released that implicate anybody by name, nor have the victims come out and pinned anybody by name as being an abuser. On December 5th, the court docketed 3 additional letters and sent those over to the DOJ. In the first letter, counsel for a consortium of victims faulted the DOJ for not redacting victims' names in another letter. They asked the court to order or ensure that the names would be redacted. Then another letter came in from the victims. Counsel for a victim's family member, John Doe, maybe that Virginia Gouveia family, who had been designated to testify at Maxwell's trial but didn't, asked that all personal information be redacted. Okay, fine. Now, in a third letter, Neil Binder, counsel for several non-party individuals, opposed their request to release these things. Neil S. Binder, several non-party individuals. The letter said the act does not authorize the disclosure of these records. So somebody is still fighting to keep those closed. Neil S. Binder. On December 8th, the DOJ responded. DOJ said, well, the consortium of victims had unfairly accused us of releasing their info. It was already publicly released, so don't scream at us about it. The DOJ said, well, okay, fine, we'll redact your names, even if you've already been publicly identified as a result of these documents. The DOJ said they're committed to respecting the victim's privacy, and they will put in place a mechanism, and if you are a victim, use this email to reach out to them. So the judge, with all of that background, says, okay, first, question is, does the Epstein Act go to the discovery materials that are covered by the protective orders and the grand jury materials? Does the act override the rules that prevent us from giving these out? And second, given the court's below holding that the act covers these records, how should the protective order be modified? In particular, discovery will be released. What about the privacy interests? All to be analyzed. Now, the judge writes, the protective order in this case that was issued by Judge Nathan covers all documents and materials. The DOJ has said, we know that, and that's why we want to unseal it. The order mainly restricts the defense. It prohibits Maxwell's counsel from disseminating anything, but it also limits the government as well. Now, the act that was passed by Congress unambiguously applies to discovery. Very clear. It governs all unclassified records, all of it. That broad formulation includes the voluminous discovery that should be coming out soon. The court thus finds that we do have to modify the protective order to enable the DOJ to follow the law. Congress said they have to, so I have to do this. So the protective order is authorized now. Now, the act does not specifically or explicitly refer to the grand jury materials, but the court is actually in agreement with the prosecutors that the act textually covers grand jury materials for 3 reasons. 1, the act talks about Gouveia by name. Indeed, the provision of the act is explicitly saying release the Maxwell records. Second, the act covers all unclassified records and all comms. So it's so broad that it also applies to the grand jury materials. The very broad language includes this. Third, the act does not exempt grand jury materials, in contrast to other acts that are exempted. Things like classified materials do not have to be released. And so if they wanted to prevent the grand jury records from coming out, they could have done that. So Congress was absolutely aware that they could have also said, we don't want the materials. They didn't exclude it, which means we got to get it. Now, a separate issue is about Rule 6E. This forbids disclosure of materials, but the DOJ is correct. The new act wins. As a general rule, later statutes can override Rule 6E, and the act implicitly reflects Congress's intent to overcome this secrecy. And now there's no ongoing cases. Maxwell's case is closed. Epstein's case is closed because he's dead. The appeals have been exhausted. And so the court holds Congress overrode the grand jury protections in the very limited context of only Epstein and Maxwell. Now, as to other grand juries, Those are all still covered by the rule. But with Maxwell and Epstein, public disclosure is ordered by Congress. And so we have to do it. So in light of the above, we modify the order. They say nothing in this protective order, in the modification, shall prohibit the government from publicly releasing materials under the Act. The restrictions of this order remain in place as it relates to victims' information or an invasion of privacy. Otherwise, give it out. An additional modification is necessary, and the paramount goal was to protect the privacy interest of everybody. That's why the original order was put in place. But the Act does the same thing, and the AG will be protecting the victims. So in moving to modify this order, the DOJ has stated we will redact victims' informations, and the court is satisfied with that. Now, the victims concerned do have a basis in fact. In its 2 rounds of applications, although paying lip service to their victims, the Trump administration has not treated the victims with the solicitude they deserve. They made their motions to unseal without even talking to them. And so the victims responded, expressing distress. I know they're very distressed out there talking about their podcasts. Says here, they're very traumatized, I know, for years. In applying on November 24th for a motion for leave, the court and Judge Berman were compelled again to direct the DOJ to notify the victims, and the DOJ hasn't been really caring. The court accordingly will require notify the victims. DOJ has pledged to honor this provision, and they're not going to identify them openly. And so, okay, we got it. They're going to be protected. We got it. They're going to be protected. Got it. And this court has great confidence that they're going to, we got it. So in light of the above, the court will modify the order saying don't hurt the victims in this case. And finally, 2 letters came in addition to addressing the construction of the act, raise issues about grand jury materials. Somebody, John Doe, said that his identity should be redacted because it would lead to the identity of a relative, which is an Epstein victim. The other letter wants a redaction of clients' names, but it may raise the issue of whether this falls within the scope of the act. The letter does not appear to seek relief under the rules. So for the reasons above, the court grants the motion to unseal the grand jury materials. We also modify the order to release the rest of the records, and all of that signed into law, or signed in and ordered by Paul A. Engelmeyer in the Ghislaine Maxwell case, December 9, 2025. So a big update on that. We're asking, what do you think the number of pages are in these materials, specifically the grand jury transcript? We got 2 of them, which means our over-under is probably going to have to change a little bit. But I think if it was 1, I forgot about the superseding indictment, but it was short. I want to say like 55 pages on one. The other one was longer, so maybe 85 pages on the other, over, under. So we'll just kind of throw those out there and see what comes down the line. But the records ordered, released. We'll see what the DOJ does, how they release them, whether there's going to be anything interesting in them. The judge said it's nothing really new or novel that he's seen, so you can have them. But ordered, released. We'll see what's inside. And of course, keep our eyes on this one. Thank you for subscribing and joining as we do. All right, my friends. What a lovely and beautiful stream it has been. Couple of good updates today. We talked about the Comey prosecution, Daniel Richmond, trying to seize evidence and keep it out of the DOJ's hands so that Comey cannot be indicted again if they have no evidence because some other judge ordered it seized and returned back to Daniel. How can they prosecute James? They can't. Going to be hard to do that. Then we went over to California, talked about this lawsuit that was filed by the Civil Division against Gavin Newsom for paying out benefits and scholarships and subsidizing illegal aliens' education, even though the law says they can't do that. Now they're being sued. We heard from Capsize Guam, from Gavin Newsom, and from the president himself before we turned our attention over to the Maxwell case and saw how those files have been ordered unsealed, and we'll be waiting for those to drop soon. But now, my friends, it is time to hear from you. Thank you for being here. Thank you for being a part of our show and joining us in all of the unpacking of the news out there. Let's see who's joining us. I saw some great donos also come in. My friends, thank you for supporting our work and for being here. You're amazing. We got some other, hey, it's Taco Tuesday. Yeah, it's Cookie Monster, who on Tuesdays switches to Taco Monster. Great to have you there. Me want your taco. Oh, gosh, got to be careful on that one. Trinal Galaxy, what's going on? Hey, 5 months as a membo. Trinal Galaxy. Happy holidays, Rob, and may we see great success. Indeed on that one, Trinal Galaxy. Absolutely. Good to have you here. Thanks for being here for 5 months, almost over halfway to a full baby in the house. War crime enjoyer. Yeah, it says if Republicans want massive wins in midterms, they have to give a reason for the voters to show up. Yeah, if they just judicial reform and held judges accountable, that would be a huge win. I completely agree. Yeah, I completely agree. Otherwise, they're just kind of ineffective people who are begging you for your support and money. So like, why? So it blows my mind. This is over from Mark Mitchell, Rasmussen, that Republicans have an investigation into Hegseth wasting drug terrorists, but not. Are the Republicans investigating Hegseth? This is what I'm talking about. Like, why should they win? Republicans have spent more time screaming about Hegseth than they have Hunter's laptop, Seth Rich, Pharma murders, Act Blue, J6, Reddit, election integrity, Ukraine corruption, Epstein, CCP spying, insider trading, tech election interference, etc., etc., etc. The list goes on and on. Yeah, and they're allowing Trump's appointed prosecutors who are actually prosecuting people like James Comey to just get railroaded with no pressure at all. And I'm scrolling around on X all day trying to prep for the morning stream and to prep for the afternoon stream. I see Democrats all day long posting, making videos, spreading their talking points around. The Republicans almost never do it. And we had an example of this before. I went through, I got them all queued up, went through all the, hey, did they say anything about Comey? No. Anything about Comey? No. Anything about Comey? No. Anything about Comey? No. But the Democrats, Comey's case got dismissed because Trump is weaponizing. Comey's a hero. He should have never been victimized. It's a whole separate game. They come out with the loudest megaphone ever, and then the Republican Party are just sitting there on their butts, not doing anything. It's really pathetic. So it's like, what do you think is going to happen if that's how you play? Pam says, this Comey thing is like Wells Fargo promising to mediate to put me off from suing for the money they owe me for making $1.4 million in rental repairs for a home they don't own, forged deeds to do a fraudulent transfer, then claiming it's litigation privilege. But fraudulent transfer is not legal, and I have so far won this fight with fake litigation privilege, and it should not be used to hide illegal conduct. Man, well, Pam, it sounds like you're throwing blows out there against Wells Fargo. Keep up the good work. Doan, Richmond trying to destroy standing of a case tossed on technicality in Eastern Virginia points to concerns over being indicted later on in Southern Florida. Yeah, so that is a good point. I don't think he wants those emails used for anything, whether it's a re-indictment of Comey or whether there's a grand conspiracy indictment that's coming down that might ensnare him in it. Go get that evidence back. It's devastating for your case. Mizzy M. Hey, I don't understand how rogue judges get appointed and then apply the law for their own purposes. There doesn't appear to be a check on that. You're right, Mizzy M. There is, but there doesn't appear to be a check on that because Congress never uses it. It's called impeachment, and they should be impeaching judges left and right now because they're acting in bad behavior on the bench. And in many cases, I think obstructing the law in a way that Congress should check. How come judges are the only ones that are deemed to be apolitical? They should be apolitical, but they're not. They're human beings, just like everybody else. And when their politicization becomes too problematic, the Congress has an actual duty to do this. And they're not. We were making fun of them this morning because in the Judiciary Committee this afternoon, they had some stupid event today about like radio and artists or something. Like the Judiciary Committee was in Congress today talking about fair pay for like artists on the radio and content creators or something. I'm like, what are you even doing? Do you know how many other higher priority issues there are than whatever the hell that was? But they're all just wasting time until the election comes and goes. They're doing nothing to help the president, and it's pretty exhausting. And why? The same grift is present on the healthcare side, Rob. If you came to California now, my hospital would hunt you down for every penny. Totally. And your credit would be wrecked. They would wreck your whole life. Medical debt destroys people. But illegals get emergency medical, something you do not have a right to as a citizen. If I reported it, it would be the last day as a licensed MD. Got to give, and he's a doctor in California. So the whole system is set up for this illegal grift. They openly threaten all healthcare workers that they cannot report one thing or suffer the consequences, because it's all about enabling the invasion of America and the dispossession of our country from us. Real with Robo, 21 months as a member. Time for a drink. Hey, U.S. Marine Corps capsizing Guam. Hold it up with balloons. I know. The Marine Corps is pretty amazing. But could they capsize Guam? I don't know. Maybe. I don't know. Maybe if I sat on the intelligence committee, I'd be as intelligent as capsize Guam. Hey, Jester Bob. Have we seen the phone company logs from the Epstein properties? No, definitely not. It seems these would be more beneficial than the little black book. We would know who he was calling and how often to include the phone numbers of his victims. We could easily create a survivor list and a predator list off these alone. Well, Jesser, that sounds like a good idea. The problem is with that is you might actually catch some bad guys. Like if you make a list like that and look at it, you might catch somebody. So nobody wants to do that. Hey, Jay Marino, it's time for Deep Pocket Patriotic Policy Organization to file a class action lawsuit against the state who gave illegal alien residents benefits for college. And are Californians mad? Well, no, we have to subsidize their education because they're poor migrants or whatever. Yeah. All right. So from that, it says all you need is one plaintiff who paid out of state tuition, numerosity, commonality, typicality, easy calculation of the damages. Just need legal rationale for private right of action for equal protection claims against the states. So Leonard S., thank you for that, says, hey, if Dems control the House after the 26 elections, they will immediately impeach Trump. I think that's exactly right. And the Senate probably won't flip, so he won't get convicted, but it's going to be like another Russia collusion hoax for years. And we're going to have to deal with that because the Republicans couldn't get it together. Hey, Curtis Bartle, 41 months as a membo. Curtis, thank you for being here for so long. I don't know how many babies that is, but it's a lot. Says life is good with MAGA, better than the other. That is for sure. Could you imagine another 4 years of Kamala? Be a dumpster, be really bad. Hey, what's going on? 41. Man, that guy looks awesome. American, like George Washington. I need to get some hair like that for this show. I definitely do. Hey, Bruce Wayne is here. 22 months as a member. What's up, Bruce? Life is good with MAGA. I second that motion. Yeah, it's much better than the alternative. And if the Republican Party became a little bit more MAGA, make America great again, not worry about their re-election campaigns, then we would be on board for that. But right now, they're too worried about Lord knows what. All right, so my friends, thank you for sending those in. Amazing comments. And we appreciate you being here. Thank you for subscribing to our channel if you haven't already done that. A couple of comments over on locals. And let's see what we got over here. Hey, Londo says, we talked about this morning on the members only stream. He says, regarding the Trump versus Marjorie feud, which we went through this morning, I have thought a lot about it since this morning's show. Amazing. My analysis of the facts that are known is as follows. Says, there is no MAGA without Trump at this time. There is no hope to save America without bad things if Trump fails. Issues Marjorie may have had with Trump could have been handled privately. The moment she stood with Democrats and anti-Trump victims, she became Benedict Arnold. And he was a hero before the fall. Works prior betrayal simply no longer matter. Marjorie's not important, certainly not as important as she seems to think. There is nothing positive that can come through the support of her defiance. Trump is very forgiving. Ask Elon. She can correct her standing if she chooses. It's not Trump's problem. Her claims of victimhood does not sound like the powerful conservative MAGA person she claims to be. Strong people who know they are right fix the problem. Liberals claim victimhood. And we made that same point this morning. Yeah. With her, like she made a commitment to complete her term and she's not doing that. So that feels like it's a little bit inappropriate. The claims of death threats is both odd and concerning. It's another page out of the liberal playbook. If they're real, it looked real based on the document she shared. I expect her to pay for security like anyone else. She's not president, VP, or any of those other things. So in other words, she knew what she was getting into. The FBI claims they are investigating. I have no reason to believe they are not. That's right. Yeah, Cash said that. Yeah, I'm on it. This is an analysis devoid of emotion beyond my desire to see maximum success of the current MAGA movement to put America back upon a constitutional foundation. Man, I appreciate that. Londo, really good analysis. And I think it's sober and you can quibble with it, but we're all trying to, I think, analyze the fracture of what it feels like is happening. And is anything fatal? Is anything like devastating, is Iran or H-1Bs or Chinese students or Marjorie fallout? Is it fatal? I don't think so. I don't think any of those are fatal. So, but the question, of course, is about what course are we on? And politics in many ways is a game of assembling a coalition. And so we're all just, I think monitoring these things and asking. One of the big questions we've had about this, which I think you did a good job answering, is about the reason for the split. Like, is it Epstein? Because a bunch of Republicans voted for the Epstein files to be released. It wasn't just Marjorie. So is it a style thing? Because there's other people that have a much worse style than Marjorie. Is it Israel? Or what is it? But it's a big fracture, and Trump is coming at her hard for sure. Londo, thanks for the analysis. We appreciate that. Hey, Bonnie, can a defendant get his DNA back if the case was dropped? Or have a right for that DNA not to be used in any future cases, says Bonnie. Not that I'm familiar with. Not unless it's like James Comey's DNA. Then maybe they would get that back. Yeah, I mean, and your name goes into a database. Like, once this stuff, the DNA is out of the bag, it's kind of out of the bag. But it's a great question. And maybe meth addicts can now sue to get their drugs back too, so they don't go to prison. Hardened Patriot says the problem with Newsom having election monitors is they would be his or Democrats and get all the Republicans kicked out of the 2020 election, and then they get away with stealing it. Yeah, their election monitors boarded up the windows so nobody could see anything, and they threw everybody out of the room. The Veil, what's up? When a governor violates federal and state laws on funds being distributed to illegal aliens, is there a precedent for a governor to serve jail time? Should be. Who were involved in putting this plan together to illegally use federal and state dollars? Not really. Not really, The Veil. But maybe there should be. It's really a traitorous type of behavior to steal money from your citizens and give it to non-citizens. How's that not betraying your countrymen, like on its face? But it's happening all over the country. And many of them are doing it saying they deserve it more than American citizens. We're going to say what's up to X. Gloria B. What's up, man? Time flies. It does fly. 32 months as a membo. It's a long time. Thank you, Gloria B, for that. Time flies, especially when we're having fun. Dark Ginger, 29 months as a membo. Says Republicans would win midterms if they just helped Trump. I agree completely. I agree. Trump is dropping executive orders all over the place, but Congress is not backstopping it. They have both houses. They're not doing anything. And they could also add a supporting role. Like, I mean, if right now there's this fracture over Charlie Kirk, Candace Owens, Tim Pool, Tucker Carlson, Mark Levin, all of these things. The Republican Party, and they're all getting blamed for like the wrecking of the party. If the Republican Party wanted to help themselves, they could come out and help take the helm over these key political issues. Charlie Kirk got assassinated. There are other Antifa people shooting and killing people outside of Texas. There's a pandemic of violence on the left coming up. No hearings, Congress not forming any committees, not looking into anything, not subpoenaing evidence, not trying to find the money connections. I mean, the J6 Select Subcommittee had stood up and been weaponized already by this point, or very close to this point, rounding up people, arresting people, and the Republicans are not doing anything. So how can they expect to win? And we played a clip this morning of Susie Wiles, and Trump and the executive branch are going to come out to do their role in campaigning over this next election cycle, but they're not on the ballot, right? They can only go so far as the candidates. And if the candidates are going to be acting like, pathetic, milquetoast, uninspiring, weak politicians, how do they think that's going to turn people out to vote for them? It's just not, I don't think. Maybe it will. Hey, Neuro D, what's going on? Good to have you over on X, my man. Thank you for sharing our Rumble link. Follow us over on Rumble as well, just in case something happens. I'm awake now. Hey, get him, Rob. Comey is cooked. I sure hope so. We got to get past the judges. We're only prosecuting, we're prosecuting these bad guys, but they've got their defense attorneys and they've got their defense judges in play, which is just amazing. Hey, Cohen Levine Hanania, what's up? Says, I know the pipe bomber is not one of the segments today, but how come, according to the neighbor, he doesn't make eye contact with her, yet Cole Jr. was able to wave for a passing police car as if he was his friend? I know evidence can be planted anyway. Nothing makes sense. Yeah, the Cole one's a weird one. We have Brian Cole obviously on our list, but there weren't any real major updates today other than that My Little Pony story. Apparently the dude was a brony. Just like, maybe we should just do like the furry brony thing. Like, what is that? Is that like some sort of infestation of the brain that results in psychopathic thinking? We'll probably have a Brian Cole segment tomorrow, but yeah, interesting things happening there too. And if his family's right, if he's borderline autistic and he confessed after a 4-hour interrogation without any counsel there, well, we have a lot more to see about that. A lot more to see. Glenn Croy. Oh my goodness, Glenn. Thank you for bringing in 10 new amazing membos. Very happy to see them come in. Look who's joining us. We've got our friends over here. Dreama Weslowski. We got Paul Verhell. We got JP. YouTube is messing with the names again. It's hard to read them. Dreama. We got Paul Verhell. We got JP. Alex I Will. Gifted membos. Bob Tube TV. What's up, Bob? Laura, Shell, The Speakeasy Lounge, Terry Bowler, all gifted membos, courtesy of our friend Glenn Croy. 3902 in the house, baby. Yeah, Jeffrey Adams says, with the departure of Laura Trump from the RNC, it is drifting back into being a feckless, useless nothing. Yeah, the RNC, I mean, what are they doing? Raising money, I guess. It's not ideal. Not ideal. But we had the election of Mamdani. Hopefully there is a little bit of a course correction. And there's still a lot of clock left. We're not in the exact throes of the election season exactly at the moment, but we're warming up. We're getting into it. So, all right, my friends, it has been a beautiful stream. Thank you for joining us and for being here on the day. We've had some good segments. We'll be back tomorrow with even more. Can't you feel it? Actually, I think we have an interview scheduled for tomorrow too. So tomorrow, I think I have to confirm it, but we should have these guys, Gary Shapley, Joseph Ziegler on the show, the whistleblowers who helped bust the Biden crime scandal, the whole crime family, essentially. So I think they're coming on the show. Got to confirm that, but that will be happening tomorrow. So thank you for joining us. They got a new book out, very sharp dudes. So we'll be back here with more membos. We'll also be back in the morning. So if you are not a membo, you want to join us on our member-only streams, come join us tomorrow morning. We have a ton of fun. We cover other stories that we can't get to here. Get an idea of what's happening in the world around us. You know, Congress, the presidency, the Supreme Court. Just keep check and tabs on all of the other things that are out there. We'd love it if you joined us watching thewatchers.locals.com or on YouTube. Click join, and we'll see you back here on the next members only stream tomorrow morning. But otherwise, my friends, we'll wrap it up on the day. Big thank yous to our amazing mods and meme smiths, of course. Muffin Rando in the house. Donut Mind Me. Thank you. We got John in here. We got K-Bean, Carrie B, Neuro D, Janek, Dog Digger in the house, along with our friends Elliot, G-Gum, and Just Rhonda, all modding the fort down for us, keeping things nice and orderly. K-Bean and Carrie B in the mornings. We love our amazing mods and meme smiths. My friends, it has been a tremendous stream. Thank you for joining us. Thanks for hitting the subscribe button on the way out if you haven't already done so. And then you come back tomorrow to get into it again, because we are going to be here. And in order to do that appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers, shining the light. Watching the watchers, defending what's right. Watching the watchers, stay each night together.